in there, and that's a lot bigger, broader, coarser. Takes a long time. It's lots of days, right? Going once. First notice is a minimum of 72. That's that notice. Let alone the time it took to get there. Possession, it could be 10 days, 12 days, 2 weeks, 14 days. That's just going once. And then second notice is same amount of time. Now you're up to a month. And so what I'm trying to say is that same pattern
replicates itself conversationally at a micro level.
In the moment, in a conversation with, if you're in court, or also if you're just interfacing with any other authority figure.
Yeah. Formal communication.
Yeah.
This.
We went over it once.
Yeah.
He didn't answer.
Yeah.
Non-response.
Yeah.
We went over it the second time. He still didn't answer.
Yeah.
Here's the third time.
Yeah.
Yeah.
But then now, how does that get incorporated into the conversation? And when you now, if you don't have any practice or knowledge as to how that gets incorporated, the conversation becomes chaos.
Right.
And so, what I'm trying to say is, first of all, we got. I'm going to write due process. Just that means the once, twice, default.
Yeah.
That's just what I mean by due process. It's that entire thing.
Right.
Process. And so now in the rules of the game, now when we're off paper and we're speaking, well, this even happens on paper.
Yeah.
There are two conversations. One is the matter at hand. What are we talking about? And so if you and I are working out something in an official capacity, right? It's a controversial issue. There's a controversy at stake here, and you have I don't. What's a hypothetical scenario? Are we working out over a check or
property?
Property. A tree falls on your land from the neighbor's place. It's the neighbor's tree, but it falls in your yard. Who's responsible for it?
And this is an interesting thing too, because James was just telling me a story of that exactly happening.
Oh, perfect.
Of what he knew of something that had happened in the area, and it got blown out of proportion, and it turned into a big situation.
Right. So as you are negotiating, you got to talk about, hey, look at what tree is it? How far over the property line is it? What agreements were set up before that? Is there any chance that where the tree came from was just because it's not on my land doesn't mean that it is on your land? Maybe there's an easement there where we both share. You have to find those things out by discussion. And so when the discussion leaves good faith and it goes off into or it just goes off into nonsense because of the lack of skill on the other person's part, or for whatever reason. Sometimes emotions get built into it and things just blow up. Nobody intends to
like if you don't get a chance to speak.
Yeah, who's got the floor? Hey, hold it, I still have the floor here. That kind of thing. Yeah, so there's two conversations, and that is the rules of the game. So you have the main conversation flow heading off this way. When you get cut off, either someone does not reply point by point. In honor is this. Is point by point. Boy, I don't know if I'm gonna have enough room here.
Unambiguous.
Yeah, I'm gonna do relevant first.
Relevant.
Is it A and T?
Close enough.
Yeah, relevant. And unambiguous. It can't be confusing. What you say has to be precision. You can't offer a gray area response so that you can fine tune it to your advantage later. You have to. Every step you take, you're making a commitment. And that's where at some point latches will set in. The conversation can never go backwards. I mean, have you ever been told that? Latches Laches, is, I think in the dictionary it says a man may not, you may not aver.
What you've already said.
The opposite of.
What you've already committed to, basically.
Yeah, the opposite of what was said.
What does aver mean?
State.
Yeah.
Okay.
Make a statement. Or allege. It's kind of the same thing. Boy, my handwriting's breaking down. So latches is you cannot aver, the opposite of what was said before. So to skip ahead in an example of that is stuff we all know is silence is agreement.
Right.
If you send somebody a notice and say, yo, this is what I think, and they don't get back to you.
And this is what I'm going to do unless you tell me otherwise.
Yep.
They don't tell you otherwise.
Yep.
They agreed.
They agreed.
Yeah.
Yep. So now they can't come out of silence later and they can't say, I never said that. Well, maybe you didn't, but silence is agreement, and this all comes down to the rules of the game. You have to be able to pull all these tools back into the conversation.
Mm-hmm.
Silence is agreement. And so 1, 2, 3 in default. First of all, there's 8 items in number 1. I haven't even put that in yet.
Mm-hmm.
And so
You're talking about the 8 items of notice.
of notice.
Yeah, right.
Of notice.
But
let's not get there yet. Let's just say we gave notice. You can't go backwards. Latches is you can't say something to the opposite of what was already said. And so if someone's silent, we know that now we're in full agreement at this point in time. We can't go backwards.
Mm-hmm.
They're in agreement. They cannot. Latches have said they can't say, hey, I don't agree with that anymore. Tough luck. You can't say you wanted it and now you don't want it.
Mm-hmm.
You can't say you owe it and now you don't owe it. You can't say you accept my check and now you don't accept it. That's the opposite of. It's outside of making a correction for a mistake.
Mm-hmm.
And so, just within number 1, it has 8 points, and you have to follow all the way through between. You can't make any assumptions or presumptions in communication. You have to fully give your opponent, your opposition, your adversary, full notice of what's going on. Hey, you did this. This is why it's wrong.
Mm-hmm.
Here's the injury that I've sustained from it.
Mm-hmm.
Or you respond, the tree fell,
Mm-hmm.
and here's the injury that I sustained from it. It busted up some of my property,
Mm-hmm.
and it cost me, well, let's not say what it cost, but it busted up the car, it tore up some ground, it did these things. These are the injuries.
Mm-hmm.
Damages is different than injury. Damages is, hey, I had to hire a guy to come out and buck this thing up with a chainsaw.
Yeah.
And I had to hire a flatbed truck to come out and get the car and haul it into a body shop and fix all the glass and the steel, and that thing cost me $6,200,
Mm-hmm.
and it was another $1,500 for to have the tree bucked up. So I don't know, whatever that $7,900.
So that's the damages for the injury.
Yeah. Let's just say it's $8,000 total.
Right.
Whatever. That's the damages.
Mm-hmm.
And so, okay, fine. You still haven't given your adversary. You still haven't given them. You haven't completed one yet.
Full notice. Yeah.
You haven't.
There's still a few more points.
Yeah, great. Okay, great. It cost you a bunch of money. You're just telling me?
Sure.
Should I go about my business?
Mm-hmm.
The rest of that notice is, okay, so this is what I expect you to do out of this. This is your duty.
Mm-hmm.
Your duty is to either reimburse me for this stuff or go down and pick up my car and take care of the bill and just bring it back to me and go to the guy that cut up the tree. Either pay my creditors
Mm-hmm.
or pay me and I'll take care of it.
Mm-hmm.
And if you don't, here's why you're in breach of duty.
Mm-hmm.
And so you have to fully explain, okay, failure to do that is breach of duty.
And then here's
So you
what
should
my
even
remedies
explain
would
the
be.
breach in the first notice.
Absolutely. Oh, it's critical. Or you didn't fully communicate. And here's what you didn't do. I'll explain it.
Mm-hmm.
And so then, if they don't pay, you still need to keep talking to them. We're still on number 1. If you don't do this, this is what I will do. And you can't ever threaten them. But, I'll defend my rights commercially, and I reserve all my rights to perhaps maintain a suit or to have a chosen action or, I would plan on billing you separately or putting a lien on your place or whatever. This would be my remedy if
This is what I could do.
Yeah.
This is what I can do.
Yeah.
If you don't respond appropriately.
Right, here's my... In other words, hey, look, I don't want you to get hurt. It's almost like you're jumping to the other side and being the attorney for the other guy and saying, hey, if you ignore him, this is what here's your
Brother,
exposure.
If this doesn't happen, then this will happen.
Yeah. And so that's full due process. It has 8 elements to it. And so what that is, that first due process is failure to state a claim upon which relief can be granted. And so that's why if you try to look up what is stating a claim upon which relief can be granted, you'll never see a clean, concise recipe for it. That's the little checklist that a judge has in his back pocket.
Mm-hmm.
He's going, well, did. Otherwise, you fail to state a claim upon which relief can be granted. Because otherwise, how do you know what you should have done?
The relief to be granted is what they should do to correct the situation.
Failure to state a claim. You haven't fully claimed anything.
Right. The relief to be granted, though, is how they would fix it.
Yes.
Right?
Yep. Yeah. And so that's why, first of all, that notice, I mean, this is kind of a rush situation. I mean, a rush talk, but kind of going back over all of this, because here's what I really want to get after is there's a forward motion in the conversation. This is a timeline.
Mm-hmm.
And at some point in time, or some event, that can stop. And you can start up a new conversation. Completely new line of thinking, completely new. And you don't abandon anything here.
Mm-hmm.
And this is really what I want to talk about, is there are 2 conversations formally, once you have all this stuff.
Mm-hmm.
And so, in that game of questions from Rosencrantz and Guildenstern are dead, he starts out, do you want to play a game of questions? And he says, well, how do you play that? And he says, well, you have to ask a question. Ah, gotcha.
Mm-hmm.
Now, it doesn't matter that whether it's a game of questions or a formal thing in law and you're talking to a judge, the instant failure happened for point by point, as soon as you're dishonored, which is you breach the rules of the game, we now have to talk about the dishonor. So that's why those guys figuratively stepped outside of the formal venue, and they literally stepped outside the painted lines to indicate, hold it, we're not playing the game now. Now I'm talking about the rules, and I'm being the referee.
So if these guys haven't seen that clip, that might have been lost on them. So basically, he says, do you want to play a game of questions?
Well, how do you
and he
play
says,
that?
well, how do you play that? Well, you have to ask questions. And at that point,
He made a statement.
He made a statement, and then he says, okay, gotcha. You made a statement.
1-0.
1 point. He was being his own ref.
Yep, that's this conversation.
So that's what's going on, is they go back and forth, and you try and always answer a question with a question, and there's a number of little things that could happen, but basically, once you make a statement or you didn't
breach the rules.
Yeah, or you breach the rules, then you call them on it. Hey, 1 point.
And you are allowed to then breach these rules to be a referee.
Right.
The rules of the game.
Right.
And so he can make a statement that says, 1-0, 1-0. I don't remember what he says. 1-0 statement.
Yeah.
You didn't answer my question.
Yeah.
Right. Statement.
Yeah.
Yep. Statement. 1-0. And they played a 3. That game they played a 3. Going once, going twice, default.
Yeah.
I got you.
Yeah.
And then but they also played 3 games to decide a winner or loser. Let's do it again. Let's just make sure. 3-3. And so statement 1-0. And so there's some other things he would say too. Hesitation. 2-1. And so hesitation is part of these rules up here. It's kind of like honor or latches or you didn't do due hey, wait
Sure,
a minute.
it would be like, it might be like, hey, I gave you 10 days to respond, you didn't respond in 10 days.
Hesitation, absolutely.
So,
yeah, but you can't call hesitation if you never told them 10 days, 3 days,
Right.
14 days, 30 days.
Right.
Yeah.
And then, again, just to, if you guys, I want to make sure that we are all following this.
Yeah.
So the non-response, right? Once you ask the question and the non-response, that would be them being in dishonor,
Uh-huh.
right?
Yeah.
What we're trying to do basically is learn what the game is so we know what the right move is.
Yeah.
And the right move is to not make a mistake. And you can make a mistake, I'm understanding now, by making a statement. So it's always better to question
Not always.
than it is to...
It's a
Bonus
good
provided.
it's a good rule of thumb though to just learn to ask questions. It's not that we would
Yeah.
never want to make a statement, but it's useful.
Yeah.
It's useful as a tool for honing our perception
Yeah.
to get used to always being able to
to make
answer
sure
a
that
question.
one statement that you may be making...
Because think about it. As we're learning this stuff, we're really used to making statements and answering people's questions with statements. That's how we've been trained, right?
Yeah.
And so it's basically just getting our mind frame into another way of thinking, so that we're training ourselves to always ask the questions back, basically.
When a question is asked, it starts out with the presumption of, like, if I say, go pick up that saw. Do you know what the subject of that sentence is? It's you, but it's assumed.
Mm-hmm.
You go pick up the saw, and you as a subject, and yet I never said you.
Mm-hmm.
And so that's something I think that escapes a lot of people is, well, what's the subject of that sentence?
Mm-hmm.
It's not even in it.
Mm-hmm.
But the subject of that sentence is you. Go pick up the saw.
Mm-hmm.
So my point is, when you ask a question, there's a presumption in front of it, which is, I command you to answer this.
Mm-hmm.
There's what's called onus probandi. The burden of duty is put on one who is asked the question. You have a duty to reply. Maybe. If you just walk up to someone that you've never seen before or interacted with before ever in your life, and you said, "Why haven't you paid me $100?" they don't have a duty to reply to you. So there's also some conditions. You know, once you're already doing business with somebody, and you see that that's how all these conditions now need to be fully explored. But the bottom line is onus probandi, the burden. Where is that in the conversation? It's whoever is asked the question. So if you're asking questions and nobody ever gets back to you, they cannot force themselves. You can't ask someone a question and they dismiss it and then proceed with their own agenda. You can't do it. Now it happens all the time.
Mm-hmm.
All the time, and if you don't know how to handle it, if you don't know how to be your own ref, hold it. You dishonored me. You weren't point by point relevant or unambiguous.
Mm-hmm.
You didn't answer my question. We can't move forward yet. You have to know how to stop the matter at hand and jump over into the rules of the game.
Mm-hmm.
Call it as a default.
And we're
Call
going
it
to
as
go
a
to
default.
number 2 if we
Yeah.
don't address this.
Yep. And then the thing is, here's something else too, is once you get to number 3, and now this is in a highly official or I don't know, what's the word I'm looking for? Not official, but formal communication. You're talking to a judge. If you get to point 3 and you've done this correctly,
Yeah.
you've defaulted him. Look, we've had 3 opportunities to handle this, and you never got back to me. You dishonored me every time.
Foreign on the record.
You don't have standing to
Mm-hmm.
You know, you don't have standing to be heard anymore. You're non-compos mentis. You're not mentally competent.
Mm-hmm.
Whether it's on purpose or whatever, I don't have the duty to talk to you for days or weeks on end so that you can wear me down by attrition
Mm-hmm.
until you trip me up.
Mm-hmm.
We got to put this. Formal discussions have to have a limitation, and you think back to the years at 1300, 1400, 1500 when there were trade fairs in the Mediterranean, for example. That's where a lot of this type of administration. You know, you're from Morocco and you sail over to the southern shores of Italy and you're doing business and you're selling spices and you want to buy some rugs and haul them back, you can't have someone just wearing you down and all kinds of nonsense. They had judges in those trade fairs and things broke down. Hey, look, get your ass over here. Let's go talk to a judge. Boom, boom, boom. And you had to know how to do this kind of stuff. Once, twice. Hey, judge, I gave this guy 3 opportunities. We can't go on forever. The judge would go, yeah, due process. Yep, you're right. This guy's non-compos mentis. Judge can't say that. You have to offer it to him, and if this whatever you present to the judge fits the checklist, and this guy's never rebutted, the other guy, your opposition, your adversary, simply has no standing to be heard. So now the judge is just going, okay, what do you have to say? Tell me the rest of the story. I can only hear you. And so if you've never been exposed to that, and now even once you're exposed to it, there's a lot of practice. And so that's what I love about that Rosencrantz and Guildenstern Are Dead sequence. Is it's short. It's 3-4 minutes. You can just go grab the script off the internet. It's just that you don't have to type it all out. And you can kind of analyze it. And maybe I should figure out a way to do that.
I know, we've been talking about that.
Could you repeat that, what was that name of that movie? Rosencrantz?
Rosencrantz, Rosencrantz, and Guildenstern, Guildenstern?
Something like that. Are Dead.
Are Dead. Actually, I have it on that computer. Right
and then if you type that in plus questions,
Game of Questions,
into YouTube, that segment would come up.
Game of Questions.
And Spence has talked about this a number of times, like in the Ben Lowry interview, he mentions it.
I love it.
But it really is. There's some amazing correlations to
court,
and to and to contracting, and it's like it's a really good little video to go check out. Wrap your head around what's going on in it.
But here's the thing too, is I'm pretty sure that even if you knew due process, and I never, you never said anything, this is so abstract that it's very difficult to see all this stuff until I scratch the surface a little bit. It's like maybe, the first time I saw The Matrix, oh, that was a good movie. I had no idea that the allegorical messages in there. But then when someone it points out, hey, check this out. Look at the similarity, the pattern that's going on here. Then once you scratch the surface, you can really dig deep into that scene.
Yeah.
And so my point is that due process that we see in a great big long process like paperwork is at the micro level in a conversation. And so there's some other rules too. We got latches, silence. Silence can be equated to fraud too. When someone owes you an answer and they just don't, that's bad faith. And so that's fraud. That mean, in other words, the judge can presume you're doing it on purpose. You're trying to deceive the other side. So,
deliberate non-action.
Willful ignorance is also. If you look up willful ignorance in law material, I think even Wikipedia has some stuff in there about willful ignorance.
So that's kind of like a creditor saying that you owe them money and you rebut their point and they don't respond. So that's basically fraud, huh?
Yeah.
And that they started, especially in that situation.
Yeah,
huh?
and that's a great example of that is a relationship that is already established and replies and responses are owed, as opposed to walking up to someone you never seen before. Right. Hey, you owe me $100.
A fresh dialogue, right?
They don't have any. They don't have any duty. The onus probandi. They don't have a duty to respond to you. And so let's see. So I don't know where else. I'd have to maybe watch that video real quick. You want to pause that and I can watch it and see? Or so when he says, so the start of that game of questions was fancy a game.
Yep.
Who says that? Do you remember? Was it Tim or?
I think it was Tim.
Okay. And then the other guy says,
We're spectators.
with spectators.
And then he says, do you want to play questions?
Yeah. You want to play questions? Yeah. Yeah.
So how do you play that? You have to ask questions.
Bam.
Statement. One
Right.
love.
Right. Right. Statement, one love. Okay. So then what's the rest of it?
Okay.
And so then the conversation always resumes from this point, not here.
Yeah. Okay, and then he does the same thing with the second one. Statement, one love.
Yeah.
And then cheating. How? I hadn't started yet. Statement two.
Right.
It's two love.
Right, because they're both still standing in the
They're
open.
still in the court.
Yeah.
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 And then he just kills it the whole game.
Yeah.
Are you counting that? What? Are you counting that?
Repetition.
And then repetition.
3 love and
Foul,
game.
no repetitions. 3, love and game.
Yeah.
So court is both the people acknowledging that they're communicating. That would be court, right?
Yeah.
So as soon as you say hello to someone and they say hello back, there you have what could be considered court, and you could
Yeah.
start a conversation.
Yeah. Do you remember when we went to court over at Klickitat County and they said all rise? That was the first that opened court. And that was an offer, and everybody that stood up accepted the offer. And so they said, we don't have jurisdiction. We need you to
We need you to consent.
consent to it. We need you to agree to it because
And
we
that-
Do
don't.
that by rising.
And that was
right?
why you probably noticed me and Spence in the front row.
We didn't stand
We
up.
didn't stand up.
We
Yeah.
didn't accept the offer.
Yeah.
And that goes back to the $100 to somebody you'd never seen on the street before. And they know that they don't. We're not in open dialogue yet. We don't have a current relationship. We need to start one. And we said no thanks. It's like somebody knocking on your door wanting to sell you vinyl windows. You don't have a relationship yet. But if you say, you know what, game on. I want vinyl windows out in my shop. Can you send out an estimator out here? And you guys start doing business, and the estimator comes out, and you sign a contract, and things move forward. Now you can't back out and say, hey, I don't want to deal with this. This is now we're into it. So back in court, all rise, and you stand up. Now, at that point forward, that's when they can cite you for contempt and throw you in jail. Whereas Nate and I never got into court by standing, and it was the same thing as us still being out in the street. You can't be in contempt of court if you're, 2 days out. We're right here. We can't be in contempt of court. There is no court. So court doesn't start until there's an offer and an acceptance.
And once I started speaking, I'd never crossed the bar
Right.
yet.
And Nate started with his offer. Nate made the offer. And so he's the first one moving. And he says, I do not consent or agree to any unstated presumptions, and I don't waive any rights. That's an offer to the court. And so by them replying, they agreed that unstated presumptions don't apply to him, and he's got everything available that he wants to claim because they didn't rebut it. And that's why that judge wanted to get the hell out of there.
Okay, and so also too though, like you were saying, court is not just being in the court building.
Right.
Court is these interactions with paperwork, with the notices, with any offer that's sent to you. That's another form of court.
Yeah. Yeah.
Documented dialogue.
Once something's been sent and you have a duty to respond to it, to stay in honor, to either rebut it or say, hey, no thanks, I don't, whatever, or to conditionally accept it or whatever. If you have an obligation to respond, and then you're opening up the dialogue, essentially that's court.
Yeah. Yeah, the trilogy of process, not due process, but the trilogy of process is notice, which accompanies all this stuff, a hearing, and adjudication. And so if when you say the word court in context to most people, 10 people just standing around a room, they're not formally trained at all. They think of, you're in court, there's a judge, a couple of attorneys, all the staff's there, right? Just generally speaking. So then what if I say trial? Now what's the difference? All of a sudden, wow, yeah, that's interesting. That's the same thing. Court and trial are two different worlds apart. Trial is the hearing. Court is the person and suit of the sovereign. So it's the man, and his paperwork is suit.
Mm-hmm.
That's the paperwork you're sending back and forth. There's court.
Mm-hmm.
Yeah. Court needs to get to trial, adjudication, a hearing. So, and that's what most people have absolutely no idea of, is that their private remedy is court. And so if you can get all the way to a default situation and you get to, and then they sue you, which happens in this mortgage situation. Everything I send out, they're dead silent, or they're not point by point relevant and unambiguous. You know, it's nonsense. And I have some pretty short paperwork to get your mind around that. There was a Citigroup sent a notice that said, hey, this is an unlawful debt elimination scam. Remember that?
Mm-hmm.
Just this general kicking sand in my face, and I had to reply right back. Well, happy to accept that on proof of claim.
Mm-hmm.
They never replied to that, by the way.
Mm-hmm.
When you know that all you have to do is your 1, 2, 3 process and stay in honor and do everything right and know how to play the rules by the game, by the time they sue you, they're the plaintiff and you're the defendant, and you let court know, the rest of the officers in the court, the judge and especially in the clerk of the court, hey, hold it, I'm actually the plaintiff on this situation. So if they're claiming to be plaintiff, well, just not to confuse everybody, we're going to call me super plaintiff. And they are the instigating plaintiff. Right? They might have instigated it, but they don't have true possession of the status of plaintiff.
And it's essentially that becomes a counterclaim.
I'd have to think about it. My instinct right now says it's not a counterclaim. It is latches set in. You just don't have any standing. I still have my original claim that just needs to get adjudicated. It's not a counter. It's not a counter.
It becomes a counter though, because the party in dishonor what becomes the instigating plaintiff.
Yeah.
Just, I don't know. From my perspective, it's kind of another way of describing it.
It is.
I don't know if that.
Yeah.
To help other people maybe get their heads around what you're saying.
Could be.
I don't know. I haven't heard anybody else talk about super plaintiff so often. As we've talked about before, it's kind of a rare thing for people to mention. But.
Yeah. I can't find it anywhere in a book. Anywhere. Unless you look up super and plaintiff. And you just know they don't have any standing to be a plaintiff. It's ridiculous. No. Nope. I'm plaintiff here.
Mm-hmm.
So if just to keep the names of the parties from becoming so chaotic that we can't track what's going on anymore.
Mm-hmm.
Okay, you want to call yourself plaintiff? Fine, I'll call myself super plaintiff.
Mm-hmm. Okay, yeah.
And when I reply to you, you want to keep that term plaintiff, I'm just going to call you the instigating plaintiff. And when you look up instigating and instigator,
it's
an intent to be malicious.
Right.
Yeah.
Yeah, I remember we had we had fun looking at those definitions that one day.
Yeah. So there's something else that we haven't in doing this point by point, relevant and unambiguous, and asking questions. Now, that there is specifically a game of questions in court. It's not just questions back and forth. There's different rules over there.
Right.
That's just allegorical.
Mm-hmm.
So, one is when words are used, and you go look up in a dictionary, not the dictionary, because there's no such thing as the dictionary, right? Noah Webster made one in 1838, something like that, 1836, 26, 1828, I don't know. Even in his own book, if you look up, I think that there's the word subject that I have open up from Webster's, and it has 19 possible entries in it.
Yeah.
And so if I use the word subject, most people would, in a context of a sentence, wouldn't ask the question and would just make a presumption as to what I'm saying and move on and don't ask questions. And when you do that, when you assume what I mean, you make a legal determination.
Okay, yeah.
So that's what I was saying with the tree and the shadow. And so this is just a super coarse sketch of, I have this tree, there's this tree here, and it's casting a shadow, right?
Yeah.
So the thought I have in my mind is that it's a tree. It's the actual thought, and a shadow is only an indication or a semblance of what the actual thing is.
Mm-hmm.
So when I have this thought in my mind, I can't just walk up to a bank teller and stare at her until she understands what I mean. She can't read my mind. So I'm limited by choice of words to use. And that's the shadow. And so from that, when you start to describe something, and you start to describe like a tree out of this shadow, and what you're saying is tree, they rebuild something else in their mind. And that's a evergreen tree. And so when someone just says, yeah, I get it, and doesn't give you any feedback to say, well, this is what I think when you say tree, you don't have an opportunity to fine tune. And so, give you an example, when a judge says to you, well, how fast were you driving? And most people would key in on, the question is one of a nature of speed. And I would say, well, what do you mean by driving? I don't know what... See, he knows what he means by that. He knows which entry in the dictionary that he's choosing when he wants to relay that thought. And so all I see is the shadow. I just see driving. I don't know which entry in which dictionary he's referring to. So I just presume he means that my wheels are in motion going down the pavement. Well, maybe he means by driving that I'm also conducting commerce and that I'm out there getting paid to go down the road. And so he's going to incorporate all those concepts into the word driving. And if I just make a legal determination, I just assume what he means and move forward, I decide what he means. In other words, I paint a picture of a tree any old way I want to and decide what he means. That is, most people are completely unaware of it. And then now once you are, that's as arrogant and not mentally competent as anything is for you to decide what someone else means. No, they're trying to relay a concept to you. And so that's another thing about making a legal determination. And part of this, in this questioning, is when someone uses a word and you don't know what it means in that world, or even if you have it narrowed down, if you say, hey, I don't know what do you mean by driving? I'm in receipt of your communication. I got this ticket here in the mail, and we have the word driving. What do you mean by that? Now, if they don't get back to you, if they just try to railroad you, because now they're going, fuck, the cat's out of the bag. I can't give up my secrets. The whole thing is to him think we're talking about one thing and we're really talking about something else. And so if you're diligently trying to have a meeting of the minds with them, now they have to use ploys like silence and being irrelevant or ambiguous. And so that's how you have to know what honor is. And to when you hear something that's ambiguous, you have to, that's not, that could mean this or this. You're still not clear. And that comes down to you have to be your own ref in the two conversations.
And that's like what we saw in the example of Rosencrantz and Guildenstern. They had to be their own ref and call.
Yep.
What if a judge states that you're being dishonorable when you're trying to be your own referee? But that's honorable to be your own referee.
Yeah, but I don't know of an exact scenario where he would just flat out declare that. And so you just judges, in my opinion, are not out to defeat you ever. And that's how it seems when one doesn't know the rules of the game and they're just nonsense out here. What happens is once a judge determines that, and you've had 3 opportunities to be point by point and relevant and unambiguous and stick to the game, that when you're not that, he has determined that you are not mentally competent, non compos mentis, and so he now, as an agent of the state, has a duty to take care of the incompetence out there, right? And so now there's no difference between someone who just won't answer him and someone who is truly mentally handicapped and needs to be brought into a facility and taken care of and managed and given meals and told when to go to bed and when to get up, and that's called parens patriae. The state has a duty to take care of those people that aren't mentally competent. And so what we see, look at how...
Are they aware that the system's designed like that?
Yeah, I mean, these guys are the ones in the know.
Yeah.
But at the same time, they can't go out and be your attorney.
Right.
They're bound, now they're a judge. Their hands are tied. All they can do is consider what's put in front of them. So my point is, when so many people are completely incompetent, that gives the judge the duty in parens patriae to just speak on your behalf and railroad you. And that's what we see all the time, and that's where that fear comes from, is because a judge damn straight has the power to do that. And so we don't know what it is that gave rise to that power. But if you're always competent to handle your own affairs, and he's not, he can't pull that on you.
And it all starts by all rise.
Or just following the rules of the game. Because maybe I do rise. This depends. I'll rise, Your Honor, but just as long as it doesn't give rise to any presumptions of that I consent to the jurisdiction of the court, or I don't grant any unstated presumptions. I don't agree to any unstated presumptions, and I don't waive any rights or remedies. I'm just here in making a limited appearance.
Also
a special
known
appearance.
as a special appearance.
Yeah, for the defendant, or as the defendant, as being in the capacity of, demonstrating that I'm not the defendant.
So that's what limited appearance or special appearance means?
Yeah, it's like
as opposed to a general appearance, which is what most everyone does unknowingly.
Right, yeah.
Okay.
Yeah. Are you John Doe? That's me. I am that. That's back to that tree and shadow. I'm making a legal determination. Because a judge will have in his mind DOE